Hi, I'm Ed Jager, chair of the Subrogation group at White & Williams. Welcome to our new podcast, Subro Sessions. You'll hear from various attorneys in our department discussing the latest legal updates, news, trends, as well as strategies for litigation, mediation, and recovery. We have a great first episode for you today titled Mindful Mediation, Navigating the Path to Recovery. Matt Ferrie, Sara, and Lian Skaf will walk through and debate 3 mediation hypotheticals. Hope you enjoy the first episode of Subro Sessions.
Thank you, Ed, and to our listeners, devoted fans, and the 1 or 2 close family members of mine who promised me they would tune in. Let me say welcome to the White & Williams Subro Sessions, and today's session, Mindful Mediation, Navigating the Path to Recovery. My name is Matt Ferrie. I'm a partner in the White & Williams Subrogation Department, and now we'll hear from my friends, colleagues, and co-hosts.
Hello, everyone. Sara here from White & Williams Subrogation Department. I am proudly counsel in the Subrogation Department.
Hi, I'm Lian Skaf. I'm also counsel in the Subrogation Department at White & Williams.
So Gus, Lian, and I were very excited when we found out that we were going to start doing podcasting. Gus, Lian, and I have done subrogation articles together. We've done subrogation webinars together. We've done virtual subrogation presentations together, and we've done in-person subrogation presentations together. We're definitely interested in adding podcasting to the mediums that we use to discuss subrogation topics and strategies. One of our goals with this is for our audience to come away thinking that discussing subrogation can be not only informative and interesting, but also fun and entertaining. So for this session, as well as part 2 of Mindful Mediation, which we're going to do next, we decided to do a point-counterpoint format. One of us is going to present a hypothetical situation that can come up in a mediation. One of us is going to present a position in terms of how to react to that situation. And another one of us is going to present a counterpoint to the first position. And like most mediations and like most cases, one size is not fit all. And that's why you want experienced and smart subrogation counsel advising you. But it's important to consider the strategies that we're going to mention because it may just fit your case. Should we get started, Lian?
Absolutely. Okay, so I get the honor of presenting the first hypothetical here that my 2 colleagues are going to spar over. I know that Matt here dabbles in boxing, and I'm pretty confident Gus does not. So Matt's the odds-on favorite, but you never know. Could get an underdog victory here.
The odds are against
I put gloves on once, okay?
And I'm going to do my best to referee. So here's the hypothetical. So as we all know as attorneys and professionals here, all states have different rules, and all courtrooms in all states tend to have differing rules as well. So same goes for mediation. Whether it's set by counsel or the mediators or in conjunction with everyone, there's different rules for different mediations. So in hypothetical number 1, we have defense counsel who is proposing that all the parties share their mediation memorandum with one another prior to the mediation. All right, Gus, you're up first.
So I am going to take the position of pro. I am pro sharing memorandums because I think most of the time, in my experience, it's been a very effective strategy, especially in those circumstances where your case is strong. If you are confident in your liability theory, you're confident in your expert, and your damages are well supported, then really there's nothing to hide. And a memorandum can be used to highlight your strengths. While there is a positive trend towards early mediations, in my experiences, mediations typically occur during litigation and after some discovery was conducted. So there may be new favorable facts that you would want to shine light on. If factual developments are potentially harmful, the memorandum then serves as an opportunity to address those facts and gives the attorney an attempt to diffuse them. So it's a really great strategy, even if facts that come out in discovery are good or if they're bad. It gives the opportunity for the attorney to put their own spin. If I do share a memorandum, then I often request that the defense attorney give their clients the opportunity to review it. And I specifically shoot them an email or send them a letter, and I say, I would greatly appreciate it if you can have your client review this memorandum as well, especially if they're attending the mediation. so that they understand our position without the defense attorney's spin on it. A shared memorandum should look different than an ex parte version. So if I don't include the fatal weaknesses that I would sometimes admit to the mediator, and I don't put actual settlement ranges. And I address those issues in a separate confidential memorandum to the mediator directly. Also, all submissions, including liability reports, I always state that they're for mediation purposes only. So big fan of sharing the memorandum in most instances.
All right, Gus, some good points. Matt?
I think I may have spoken too soon. I think Gus might have got me by technical knockout on this one. Unfortunately, this is one of the hypotheticals where I don't think the counterpoint is all that strong. It should always be evaluated on a case-by-case basis. But generally speaking, you want to take advantage of any opportunity to directly communicate your position in writing to the decision maker on the other side. That being said, there are some factors that you should always consider. For one, the stage of the proceedings. If it's pre-litigation or early in litigation, there's often little downside to providing a mediation memo to the adverse party. However, if you feel that you have made your position abundantly clear, whether it's through an expert report, motion practice, whatever may have developed in a lengthy litigation, a mediation memo to the adverse carrier may be redundant, or perhaps more importantly, maybe a non-optimal use of your time on that particular case. Another thing to consider is the strengths of the case may best be articulated in person. The facts and the circumstances may be such that a written summary actually does not present the case in its best light. An example of this may be when the defendant or an important defense witness has come across very poorly in his or her deposition, and that may be much better communicated in person. Another factor to consider is how much you communicate in the mediation memo if you're going to send it. While some candor in articulating both the strengths and weaknesses of your case, I feel will go a long way in facilitating a productive mediation, a mediation memo to the adverse party is not the time to present a laundry list of everything that is wrong with your case. You want the defense attorney, when he's done reading your mediation memo, to think that you have fairly presented a strong case. You don't want him to think you're going to end it by saying, "I'm sorry for wasting your time. Please give me $5,000 and I'll go away." Similarly, if you do provide a mediation memo to the adverse party, you want to be mindful of the ongoing balance between providing enough information that the adverse party recognizes their exposure, but not so much information that they can begin to develop defenses they had not previously considered evaluated. This is not to say hide the ball on the most important positions in your case, only that you don't necessarily want to give away every argument, particularly if you don't feel that this mediation is going to be productive.
I wish I had a wrong button to hit several times, but good job.
I think the boxing commission may be taking a look at you, Lian.
Let's agree to disagree.
All right, hypothetical number 2. I'll pass the baton to Matt.
Okay, so this is a situation that we come across all the time, and that is that defense counsel wants the plaintiff to either make a pre-mediation demand, which is lower than its total payment, or make the first move in the mediation if there has been no prior movement regarding settlement discussions. So in terms of our points, we're going to start with Lian. What do you think, Lian?
Well, I mean, it's obviously depends on the circumstances of the case, like, most things we're going to discuss here today. But, generally speaking, all mediations have one thing in common, it's that all parties need to come into it with good faith that they're really trying to settle this. So, we expect defense counsel to come ready to settle. And, I think making the first move gives them a clear sign that we're coming in there doing the same. If they don't reciprocate and they don't come up, either matching you or what you think is a good faith counter, then pretty quickly whether or not the settlement is really possible here. And, you kind of know, look, I put us out there. It wasn't responded to properly. Let's move on. I also think making the first move can often curry favor with the mediator. I mean, the mediator's goal there is to try and get this case settled as quickly as possible. And I think making the first move furthers that goal. It's good to capitalize to use this also when you're later trying to convince the mediator to lean hard on the defendant or their defense counsel to put up some money to say, hey, look, we started off here. We made the first step. Let's get them to throw in some money at the end. Especially when you have the defendant, the client there, I think it's good to show them that, you're not some unreasonable ambulance chasing attorney that defense counsel may have made you out to be. It's good for you to make the first step, set the tone for the mediation, and, show that client that you're reasonable, and that you're agreeable and they can work with you. That could help later in the day in the mediation when things get tight. And even if you don't settle, if you're pre-suit, it can help you once you're in litigation. If you're in litigation, it can help you as things go on, just so they know they're dealing with a reasonable person on the other side. If later pressed by a judge, let's say that the mediation we're talking about is with a private mediator, sometimes either at a pretrial conference or before, you'll get into a settlement conference with the judge, and he'll want to know the history of your mediation, what counsel did, what they didn't do. I think it's good to be able to tell a judge, listen, we made a first move. We lowered our initial demand. We're acting in good faith. I think you can also have the benefit of lowering your demand while surrendering some damages that you might not necessarily really expect to recover anyway. I mean, this could be in the form of depreciation or interest that, you might make the argument is recoverable if you're at trial, but really it's just a chip you're going to use in a mediation anyway. So, you're showing some good faith and you're not really surrendering all that much. I think also, your client agreeing to make the first move kind of gets them in the right positive frame of mind too, in that, we're here to try and settle this. We're here to move the chains and do our part. And hopefully defense counsel will do theirs, and, we'll get to a settlement by the end of the day.
Lian making some points with the judges so far, Gus. What do you think?
Did he, though? I think that was a very eloquent, admirable presentation of your position. But I respectfully disagree with everything you said. Why bid against yourself? The case is going to mediation either because defendant was unwilling to even engage in settlement negotiations, or negotiations were attempted and failed. Even if prior negotiations were attempted, there is usually a clean slate at the mediation. So if the defendant is starting at 0, shouldn't the plaintiff start at 100? The mere fact that defendant agreed to mediation does not in itself warrant a discount. Sorry, not sorry. There are other ways to get in the mediator's good graces. I have never had a mediator get upset with me or my client for not dropping the demand prior to the mediation. The plaintiff's good faith agreement to participate means the plaintiff will compromise at the mediation, but not beforehand. I would expect that by the time the mediation comes around, defense counsel knows me well enough and should know that I'm reasonable without having to come to a mediation with a reduced demand. I find that I'm usually in a mediation because the defendants were the ones not being reasonable. Call me biased, but that's usually my take of the situation. I'm often waiting for them to show a sign of reasonableness, not the other way around. Even if there are portions of your demand that are not legally recoverable, why not wait until the mediation to negotiate on those portions as well? You may agree to reducing your demand first while at the mediation, but there is usually little benefit to drop your demand before the mediation.
Lian, do you have something in response to that?
Yeah, I just want to say I think the only thing we really learned here is that I'm a nice guy and Gus is not.
Gus is not here to make friends.
I'm okay with that. I'm okay with that.
Yeah, I might have to call it, I'm going to call it a majority draw. That means there's 3 judges and 2 of them decided it was a draw. And I'm not going to tell you what the third judge thought.
I don't remember asking you, Matt, but moving on to hypothetical 3. So we're at the mediation and the mediator proposes that all defendants stay in one room and that all plaintiffs stay in one room. And obviously this is a case in this hypothetical where there are multiple plaintiffs and multiple defendants. Pros and cons to keeping everyone on one side of the V in the same room. We're going to start with Matt.
I'm generally going to be in favor on this one of keeping all of the plaintiffs in one room, at least to start a mediation. Generally speaking, a united front among plaintiffs has obvious benefits in terms of how seriously a defendant or defendants are going to be taking their exposure. Additionally, to the extent that it's not already obtained, it's an opportunity to learn additional and or potentially better arguments than those we've already developed through our investigation. Personally, I think it's a poor attorney who thinks that he can never learn anything new about how to present a case or can never learn anything new about his own case. And I think it's always a good opportunity, especially if you're working with co-counsel or other plaintiffs' counsel whom you respect and also has a good feel for the case, to try to understand what their viewpoint is and see if they have some points regarding this case you had not considered or perhaps had dismissed too easily. Another point is you can better understand the settlement expectations of the other plaintiffs, and you're in a better position to ensure that your client is getting a fair share if you're in the same room with the other plaintiffs, and if a combined offer is being made, or at least you have some understanding of how that offer is intended to be split up amongst the plaintiffs. It may also make the mediation progress more smoothly, more efficiently, and more quickly. There's just generally an inherent momentum that comes along in moving the mediation forward when people are not constantly in their own breakout rooms and no one's there to kind of call them out and say, guys, come on, what are you doing here? Why are we fighting over this? Let's try to get this done. That being said, I think there is another important point to make is sometimes you start a mediation with all plaintiffs in the same room. And at some point you realize it's not working out. Every so often you'll come across one plaintiff who chances are he or she, the attorney, is the one who did the least amount of investigation, has the least effective expert, and for some reason is being the least reasonable in trying to settle the case. So to me, it's kind of like Dalton said in Roadhouse, where he said, I want you to be nice until it's time not to be nice. It's kind of like, I want you to be united until it's time not to be united.
Lian's in the corner.
All right. Like all of our topics, there are arguments and good ones to be made on both sides. But this is, I guess, where I go from nice guy to heel. This is Hulk Hogan into Hollywood Hogan here. So are we in the same room? Look, I'm all for camaraderie. Camaraderie is important. We got to all be friends here. But so is zealously representing your client. We all remember that, right, from law school. So in these cases, a lot of times, one of the biggest issues is damages proofs. Your co-plaintiffs are going to have different damages than yours. Some are going to be inflated. Some are not going to be as supported as yours. And that can mean arguing against, recovery that's not going to be divided equally. And, in those circumstances, you want to present your case to the mediator outside the presence of your co-counsel. You don't want to be disparaging their damage proofs in front of them. And you also maybe don't want them to know you're making that argument to the mediator. I think also just, more generally speaking, not all clients value cases the same. A co-plaintiff might think they have a strong case that they will turn away a decent offer at mediation. And your client might say it's not as strong and they might want to take it. Whether or not you can actually get that to work and without a global resolution with defense counsel is another story. But it's certainly something I think worth trying. And I think a lot of times to do that, you probably have to be in different rooms. Sometimes, a client is also more maybe apt to be open with a mediator when other co-plaintiffs aren't in the room with them. It may not be the specific facts of this case or not. We're all dealing with insurance companies and clients that run into each other all the time over and over again in different contexts. So whether it's some prior history you don't know about or just their general comfort level, your client, may be able to talk bottom lines a little bit better directly with the mediator without a different representative in the room. From a personal point of view, having the room to yourself is, a good chance when the mediator is not around to bond with your client. I mean, that's some good FaceTime right there. And, for both of you, maybe it's just a good chance to get some work done when the mediator's not around.
A nice person would say that was a draw, but I'm going Lian. I completely agree with those points. So we're on to wrapping this up. This has been a lot of fun, and I hope Matt's family members agree.
I'm pretty sure they're not tuning in.
Well, at least your family was nice enough to lie to you and say they would. So as we've learned, no two mediations are alike. The details of your mediation may lend itself to its own unique strategy, but hopefully some of the points here can be helpful in deciding how best to proceed. Some of these strategies may also depend on the style of the mediator. So it is helpful to know the mediator, at least to have an understanding of the mediator's style. When a mediator is recommended that I'm not aware of, I send an email out to the group to see if anyone could shed any insight on that mediator's style. Some mediators obtain a very good grasp of the facts and articulate each party's strengths, while some are less aggressive and leave it to the attorneys to make those points. The style of the mediator is definitely an important consideration.
I'll just add also, I think it's important to the extent you can talk with your adversaries, counsel, if you have the opportunity, the clients at the beginning or even during a lunch break about topics other than your case. Show them you're a good person, set an amicable tone so that all the participants feel like, you're working toward the same goal here without really needing to get into specifics of the facts, just generally speaking. If the mediation is unsuccessful, don't assume settlement's impossible. Sometimes it may just take a few more days for the parties to contemplate or a few more phone calls to get things done.
My general philosophy is that any mediation is hardly ever a waste of time. In my experience, defense attorneys typically have a mindset to litigate the case longer than it needs to be litigated before thinking about a resolution. A mediation provides the opportunity for the adverse party to shift their thinking towards resolution. Even if the mediation is unsuccessful that day, you and the client typically come away from the mediation with a better understanding of the adverse party, the defense arguments, and the likelihood of future settlement. So I would say almost always, if there's an opportunity to mediate, you should give it a shot. And that is going to conclude Subro Sessions, Mindful Mediation, Navigating the Path to Recovery, Session 1. Please tune in for Session 2.
Thanks for listening to Subro Sessions. We'll be back next time with part 2 of Mindful Mediation, Navigating the Path to Recovery. Matt Ferrie, Gus Sara, and Lian Skaf will walk through and debate 3 different mediation hypotheticals. In the meantime, if you have any questions or suggestions for future topics, email us at whiteandwilliamsinfo@whiteandwilliams.com.